This is attorney ATTY Frekhtman, and today I wanted to talk about a follow-up from the last video. In the last video, we talked about the difference between how an insurance company values a personal injury case versus what it could be truly worth if it was taken to trial before a jury, and how a lawyer who's prosecuting a case representing an injured client should not be inundated with that insurance company valuation, because it's like a limiting belief. If the lawyer just, agrees with that insurance company valuation, then the lawyer has a very low ceiling and he doesn't see the possibility. And then as a guide for that client, then he's going to tell the client there is no possibility. And then now you're in like a prison, a self-made prison, and you're never going to break out and you're never going to get what the case could potentially be worth. And one of the examples I gave was there was almost a $10 million verdict out in California recently, and it was on a non-surgical 2mm herniated disc. Very simple, conservative treatment, no surgery. A lot of the findings were normal, and the lawyer had a lot of problems. But the lawyer believed in the case. He went in there and he actually got $9.7 million, which will become, with interest and other issues, it will become $12 million. So he's going to get paid $12 million on this case. So it's just, a lot of people in the last video, one particular individual commented on that, and he asked, well, tell me about this case. I really want to know about this $10 million case or $12 million case. So I'll tell you a little bit about it. I watched a CLE, a continuing legal education program about it. And so I know a little bit about it. And I'm going to learn more about it in the coming weeks, because there's going to be another program with the lawyer who actually tried the case. He's going to put on a program, a trial college out in California. I'm not going to be able to go because I'm going to have my own trial here in New York. I'm doing a trial out in Staten Island. So I'm not going to be able to go there, but it's going to be live streamed through Zoom. So I'm going to try to attend the live stream. So anyway, this case. So this was a car crash. Somebody was rushing home and the defendant was rushing somewhere. And he basically, ran a red light, and it was a head-on collision, and he crashed into the plaintiff's car. Plaintiff was just stopped at a red light. So the issue of who was at fault, liability, not an issue. It was completely on the defendant. The property damage was serious to one of the cars, I believe the defendant's car, but to the plaintiff's car, it wasn't that bad. It was, there was some crushed metal. It was something, but it wasn't that bad. So these were the issues in the case. And the way that this lawyer approached it was very interesting. So basically he said, I'm going to be very confident in the case. I'm going to say, look, I can't wait to show you my case. I have a great case. I'm going to tell that to the judge. I'm going to tell that to the jurors. I'm very confident in my case. But when I go up in voir dire, I'm not going to talk about all the, beautiful things about my case. I'm going to talk about all the problems. So what were the problems with the case? Well, number one, it was conservative treatment, right? Meaning somebody was injured. They went to the physical therapy, they went to doctors. There was never any surgery, there were never any procedures. I don't even believe there were ever any epidural injections or percutaneous discectomies or pain management. So there was no surgery. There was a question about possibly issues with the brain, and a brain injury workup was done, but all of the scans, the MRI, the DTI, the diffuse tensor imaging, were all normal. The lawyer was requesting and seeking tens of millions of dollars. So that was obviously a problem for some jurors, right? That's something you have to bring up in jury selection. There were no non-economic damages, meaning there was no lost wages. The person went back to work 4 days later, and there were no other types of non-economic damages. Non-economics were very low. He worked full time. And actually, after the crash, his income, his salary doubled. So he made much more money after the crash. And he was able to purchase a bigger house after the crash because his salary improved. And his love life, like with his wife, wasn't affected. They were still, intimate with each other afterwards. It didn't really affect their love life. So what was the injury? The injury was a herniated disc. And it was a herniated disc I believe to his neck. It was only 2 millimeters, a 2 millimeter herniation, which is a relatively small herniation. And he also had an issue with brachial plexus stretching, where, because you have the nerves coming from the neck to the arm and the brachial plexus, and there was an issue with some stretching, but it wasn't really diagnosed. There wasn't too much objective medical evidence. So there's a lot of components, right? There's a lot of things to talk about. I think the CLE program itself was like 3 hours, so I can't go into everything. But I think today what I'd like to talk about is the voir dire, the jury selection, just to explain the mindset, right? And how to pick a jury that would be fair and possibly favorable to a plaintiff. So like I said before, all the good facts get put on the back burner. Don't talk about the good facts. You talk about them later during the trial, or you save some of them, because if you start being an advocate right away and you start talking about all the good facts, then the jury might, play devil's advocate and tend not to believe you. But if you play devil's advocate as the plaintiff and you start talking about all the problems, well, now it's good for two reasons. Number one, the jurors, the panel that you're talking to, are going to think, well, this guy is being credible. He's being honest. He's talking about all the problems, all the issues right up front, right? So that's a good thing. And number two, it's good because you're going to get some jurors on that panel that are not going to agree with millions and millions of dollars for a non-surgical herniated disc. People are settling cases like that for $5,000, $10,000, right? So you're going to be able to get so many people off for cause, because a cause challenge, it's different in every state, but it basically means that the juror cannot assure the court that he or she will be completely fair and impartial. And why? Why may they not be completely fair and impartial? Well, one of the reasons is because they may have certain beliefs, right? We all come into a trial with who we are and who we want to become. We all have beliefs, opinions, just thoughts, feelings, whatever you want to call it, parts. People are Republican, people are Democrat, people believe in this and that. So what you want to do is you want to explore those beliefs. So what he did was he actually, first of all, I think the first question he asked was, he said, are we all starting, if this was a race, are we all starting equal? Is it the same starting line? And then he talked about the case and he talked about the issues, millions and millions of dollars for, how do you feel about that? And then the jurors, because they had so many people, they had 50 people, and then they kept going through panels. So I'm not sure exactly how it works in California. In New York, usually you get a panel of about say 15 people, and you talk to the first 8. And then you explore everything, but everyone else is listening to it too. So then because you have about 15 people in the room, so then when you're done with the first 8, you go to the next 8. You don't have to rehash everything. You could rehash some of the issues, but people have been listening, so that's the way they do it in New York. So anyway, so one of the main issues he asked was, he said, what if there's a conflict between your beliefs and the judge's instructions? So for example, your beliefs about a case, a personal injury case, a car crash, where somebody's coming into court and asking for millions and millions of dollars, and there's this, let's say non-surgical, I don't know if you can't really get into the evidence, but so you can't really say a non-surgical herniation in voir dire, but you just say, just what about that? Millions and millions of dollars. Are you able to allow for that? And then a lot of people are going to say no, right? Because there's a whole, the insurance industry is doing this whole thing with tort reform, like, oh, there's so many lawsuits, lawyers, they're making so much money, they're greedy, so any of that stuff. So as soon as jurors hear that, they're going to say, no, I wouldn't agree with that. I wouldn't give, tens of millions of dollars, especially if there's better be a life-changing injury, otherwise I wouldn't. So what he does is he contrasts that with the judge's instructions. And he says, well, what if there's a conflict? Like, your beliefs differ from the judge's instructions. Which one are you going to follow? And a lot of the jurors said, no, well, I can't just, set aside my beliefs. I could try, right? Like brutal honesty. What is your truth? And then the juror would say, well, I could try to set aside my beliefs, but those beliefs might creep in. So then, what are you basing your decision on? Is it the evidence in the case? Is it the evidence and the law that the judge instructs you on? Or might your beliefs that you've had, or your feelings, your opinions, creep in? And could they influence you, right? And that's where the jurors could not give that assurance that they would be completely fair and impartial. They couldn't give the assurance to the court. And he was able to exclude 57, I believe, jurors, 57 jurors from the prospective panel. And then the only people he was left with are people that would be fair and would be able to allow for tens of millions of dollars. So you see, that's a really brilliant thing to do. So one of the ways he did that was that question about beliefs versus instructions. The second way was he just, a lot of people were against the case. They actually had 7 insurance adjusters as part of the panel. So these insurance adjusters, who are paying out claims for like Liberty Mutual, State Farm, Geico, they were sitting there. They could have been potential jurors. So so a lot of people were talking, basically, talking shit about his case. They didn't like the case. They didn't like lawyers. And see, the old school way would be, oh my God, you poisoned the panel. You said something bad. But the new school way, the way that a lot of these lawyers are handling it is they actually welcome that. They stand in the fire. They walk into the fire and they're strong and they're just like, look, I believe in my case. This is what the case is about. I can't wait to show you the case. I can't tell you all the evidence. I can't wait to show you a trial. But this is a great case. And so could you be that fair, neutral, impartial juror that we need? And then people will be like, well, but tens of millions of dollars. I don't see it. I have problems. I don't believe you. So then once he established that, right, like we talked about before, and everyone has already heard some of the issues and some of the typical tort reform issues, like, oh, what is he going to do with the money? Why is he getting, like, my uncle got hurt and he didn't get tens of millions of dollars, so why should this person get tens of millions? All these beliefs against lawsuits and issues with tort reform. So then once it's all out there, right, all the issues are out there, then he just stands up and he just says, well, can I earn your trust? And then a lot of people would just be like, no, I'm sorry. I just have these strong beliefs. You can't earn my trust. And the other thing about it is because the jurors are smart, right? The perspective, the panel members, they know that if they say, yes, you could earn my trust, potentially, yes, I could be fair, I could assure the court that they're going to get put on the trial. And a lot of people just don't want to be put on the trial for whatever reasons, right? People don't want to serve on jurors. People want to get off and they want to do other things, like just go hang out on the beach or go back to work, or they're going to lose money or whatever. Maybe they have businesses and they can't afford to, be on a jury. So they see that as an easy out. And, and it is an out under the law because you have to be fair and impartial to both sides. So what he's doing is he's getting rid of all the bad jurors, leaving all the good jurors. So it's really a brilliant way. And then the final way he did it was he asked, well, in spite of your best efforts to put aside these feelings, beliefs, opinions, could you assure us that you'll be completely fair and impartial? And then a lot of people would say, no, I could try. Well, but you have to give that. Trying isn't good enough, right? You have to be 100% that assure us, because it's like, you don't turn your beliefs on and off like a light switch, right? You may try, but then the same exact fact, let's say it's the same exact fact, you could reach different conclusions from the same fact. And so if one person believes against lawsuits, he'll reach the conclusion, hey, it's worth $5,000. If somebody is more neutral or believes that people are entitled to civil justice from that same fact, they might say, okay, it's worth 10 million, right? So that's a way to do it. So I think it was pretty good. And in general, I think that voir dire was very good. It was very intelligent. And I'll do more videos. I don't want to make this one too long, so I'll do more videos later. I can talk about other things. They also have what's known as mini openings in California. So a mini opening is where they just briefly describe the case before the jury selection. We don't have it in New York, but you could probably do it and just as part of a voir dire, because when you start your jury selection, you don't have to start just with questions right away. You could give a little bit, like a 30-second, 1-minute introductory speech. So that could be the mini opening, and then just you don't have one formally, but you could easily fit it in there. So and then they talk about their openings, they talked about witnesses, they talked about closing arguments. They actually really thought about their case. What they did was they used certain metaphors and certain ideas. So they would start the metaphor in jury selection, right? And then they would talk about it more in opening, and then they would maybe discuss the issue or the metaphor with certain witnesses, and then they would save it, and then boom, at closing, they would bring it back hard, and it'd be like, oh my God. And then the jurors would just be, very much inclined. And that's how they got the big verdict, the $10 million. So I'll talk about other aspects of the trial, maybe in other videos, but this was just the one about jury selection, how to approach it, the mindset, how to do that. It's almost like group formation, because you're forming a group, but some people call it designed alliance, because you're saying, well, how many people here have feelings against lawsuits? And then people raise their hands and people say yes. And then who else, and things like that. And then you get all the bad people off, all the rotten apples, you leave only the people who can be fair. And that's how now you have a chance, right? Now you have a chance, you have a jury that could allow for tens of millions of dollars. Because if you don't ask the question, or if you don't get the people off for cause, you only have two preemptories. Preemptories are, you can get people off for any reason, right? So that's only two challenges. That's very little. So if you're not using your cause challenges effectively, if you don't know the pattern jury instructions in your particular jurisdiction, then you're at such a disadvantage, right? It's almost like flipping a coin. You don't know. You might get a good jury, you might get a bad one. So you might get 10 million, you might get zero. And most of the time, you'll probably be closer to the zero, right? So this is a really good way to do jury selection. And that's the way we do it as well when we're selecting a jury. So I hope this has been helpful. Like I said, we're going to do more, because I'm going to go back and maybe try to watch that entire CLE. It was like 3 hours long, so I only watched part of it. And then we're also going to do that program with them, the trial college, by live stream. So once I do that, I'll learn more, and I can do more videos and talk about this case as well as other cases. And then I'll be sure to talk about the case I have myself in New York City coming up towards the end of April. Okay, talk to you soon. Have a great day. And let us know what questions you have. We're here for you. Okay, bye-bye, everyone.